All right, we will go ahead and begin. Well, welcome. Good evening, maybe afternoon, depending on where you're located. My name is Keisha Bradford, and I'm a program manager here at Doctors for America. Before we begin, I'd like to take a quick minute to invite you to officially join Doctors for America. Becoming a DFA member today means helping us provide excellent educational and advocacy programs like this one. Please consider joining DFA as a paid member. And if you sign up now, you'll actually save 15% off your first year of membership, a fun little code promotion that we're running. So this information will appear shortly in the chat. Just so you're aware, we will be recording this presentation and all materials will be available afterwards. Today's presentation will go until 15 minutes past the hour, just because there's such a wealth of information to cover. So before we begin, just a few ground rules here. So there's no such thing as a stupid question. And speaking of questions, please, please, please use the Q&A feature, as we'll be monitoring the questions as they come through. And so we'll make sure that your question is answered in a timely fashion. Sorry, just making sure that the information is put in the chat there. And so now for the fun part. Now on to our speakers. So very thrilled to welcome Alyssa Morrison and Khadijah Silver. So first, Alyssa Morrison works as the reproductive justice staff attorney and in-house expert on reproductive health policy at Lawyers for Good Government. Actually, prior to joining Lawyers for Good Government, Alyssa spent 5 years working in constitutional impact litigation at the federal level with the Constitutional Law Center for Muslims in America. In that role, Alyssa's practice was focused on challenging racial and religious discrimination in federal trial and the courts across the country. Alyssa is in good standing with the Texas State Bar and brings a passion for individual liberty with her experience in constitutional law, civil rights, and advocacy with her to Lawyers for Good Government. So welcome, Alyssa. And now on to our next speaker. Khadijah brings to Lawyers for Good Government over 20 years of experience helping community-led coalitions unearth, understand, communicate, and uproot the causes of systemic injustice. Khadijah most recently served as, the communications director at Transgender Legal Defense and Education Fund, where they led narrative change strategy for trans and non-binary civil rights, working in strong, respectful partnership with national and grassroots organizations. Prior to that role, they served as a health law and policy journalist with bylines at Med City News, Above the Law, Law 360, Institutional Investor, Popular Science, Refinery 29, and many more, I'm sure. They are a member in good standing with the New York State Bar. So welcome, Khadijah. And now I'll turn the floor to you both to go ahead and get us started.
Amazing. Thank you so much. I'm just going to pull up the slides, and then I, Khadijah, supervising attorney for civil rights at Lawyers for Good Government, am going to be the slide master and let Alyssa kick off our presentation. That is, if I can find the window that I have open with the slide, because it's just, there it is. It's just one of those days.
There.
All right. Can y'all see?
Yes.
Amazing. So I'm going to start the slideshow, and it is on.
I think we're on like slide 18 there.
Hope.
Pop into the top.
I am telling you, it is
spoilers.
I know, I'm like ruining everything.
No, it's the end of the day.
Yes, I am so sorry, y'all. I'm here in Brooklyn, New York, and you hear my children in the background. So I apologize. I'm like a little distracted, but kick it off, Alyssa.
All right. Yes. So hi, everyone. We are so thrilled to be here today. And thank you, Keisha, for those wonderful introductions and for giving us this time. So I'm Alyssa Morrison, she, her, and I'm the Repro Justice staff attorney here at Lawyers for Good Government. And I work alongside and with alongside Khadijah as both my supervisor, my colleague, my partner in this work. So just quick agenda, and I'm probably going to be talking really fast tonight, both because I talk really fast all the time and because we have quite a bit to cover. But so just some quick opening remarks, introductions, etc. And then the main part of what we want to talk about is the new HIPAA privacy rule and how that relates to reproductive healthcare privacy law. And then quickly go over some of the 2024 Supreme Court decisions and how those relate to healthcare and the practice of medicine. Some of the trends that we're watching, just a couple that we pulled out as particularly important, and then of course our Q&A section. And as Keisha mentioned, if you have questions along the way, please feel free to drop them in the chat, or in the Q&A function rather. Legal disclaimer, it's not legal advice, you know, providing a high-level overview, please consult your attorney, so on and so forth. Okay, so just a quick, super high-level overview of who Lawyers for Good Government is, if you're not familiar with our work. So we're an advocacy and policy organization or nonprofit fighting to preserve and protect basic civil and human rights across a number of different spheres. We do this by strategically combining the expertise of our in-house staffs, our in-house attorneys and support staff, with the strength and scale of our nationwide network of 125,000 plus lawyers and advocates. We believe strongly that every attorney, advocate, and person is capable of fighting for those rights, and we work to train and mobilize folks to be able to do so. And our primary focus areas here at L4GG are repro justice and health equity, which is obviously who you're hearing from today and what we'll be focusing on. Our Immigrants' Rights Project, Project Corazon, which works down here, I'm located in Texas, works here on the border in Texas, as well as up in New York with our clinic for asylum seekers. And then our climate change and environmental justice team, who is doing amazing, really critical, really complicated work to save our environment and keep us all healthy. Next slide. So, okay, we will jump right in. So HIPAA and reproductive health. Quick HIPAA overview. Obviously, I'm preaching to the choir here. You guys know HIPAA far better than I do, likely, but just to kind of, you know, start us off. So HIPAA, of course, generally prohibits disclosure of PHI, protected health information, in order to safeguard patient information from being shared without their permission or consent. Generally speaking, PHI is information that identifies or could be used to identify a person, including their name, date of birth, address, so on and so forth. And that information relates to data about the person's past, present, or future health, the provision of healthcare to the individual, or information about the past, present, or future payment for the provision of healthcare. Although PHI is generally protected, there are, of course, exceptions for things like public health activities, judicial and administrative proceedings, research purposes, some research purposes, and certain law enforcement purposes. And I think it's just important to note, you know, from a non-medical perspective, I think that there's sometimes a common misconception among patients and those outside of the medical field that HIPAA is kind of a blanket protection for any information related to their receipt of healthcare, like that it's sort of an attorney-client privilege situation where you just put everything in the black box and it can't be disclosed. And of course, while HIPAA is protective, it doesn't protect everything. And so, you know, the way the patients handle their information and providers handle their patients' information remains super critical. Next slide, please. Okay, so the HIPAA privacy rule to support reproductive health care, which I'll just call the reproductive health care rule. So in quick summary, what is it? Why do we have it? And when does it go into effect? So on April 26th of this year, the Biden administration promulgated the HIPAA privacy rule for reproductive health care. The goal of the rule is to strengthen HIPAA's provisions specifically for reproductive healthcare information in a post-Dobbs landscape, so since Roe was overturned by Dobbs. Why do we have to do this? So after, as I'm sure you're all aware, after Dobbs overturned the federal right to abortion that had been established by Roe and Casey, a patchwork of state-level laws, abortion laws, and bans popped up all over the country, a really, you know, complicated web of very confusing non-medical laws. Many of them have harsh civil, criminal, and professional consequences attached for providers who are found to have run afoul of those laws. So the need to protect reproductive health care and those who are providing it and those who are seeking it, you know, is higher than ever. So in recognition of that, the Biden administration promulgated this rule. So some of the things that we're seeing that kind of raise the temperature of the current environment. So several states are seeking to criminalize interstate travel for abortion. Idaho and Tennessee have already passed so-called abortion trafficking laws, and are currently fighting in court to be able to enforce those. We will see what the outcome of that is. States have enacted or are trying to enact harsher reporting requirements for abortion and abortion-related procedures. So basically, that's the state seeking to obtain, consolidate, and in some cases make public patients' abortion-related and reproductive healthcare related decisions. And then there's concern about a rise in fetal personhood laws, which could lead to increased criminalization of miscarriages, abortion, and conduct while pregnant. So increased criminalization and surveillance. And of course, reporting plays a huge part in that, and patient privacy plays a huge part in the ability to surveil and criminalize pregnant people. Things like Project 2025, which I'm sure you've seen all over the news in the last few weeks, call explicitly for heightened pregnancy surveillance at the federal level. And we've seen abortion hostile states embracing that same approach. Certainly my home state of Texas falls into that category. And then the need for patients to leave their home state to obtain care increases concerns about the sharing of healthcare information between states and between hospitals and clinics in other states. So for example, if a patient, leaves Texas to go to California to obtain care, when and how are those records protected when they return back to Texas? And I should add to this list that just the fact that, 14 states now outright ban abortion, with many others severely restricting it, as early as 6 weeks, 8 weeks, 12 weeks, and so on and so forth. And covered individuals and entities must comply with the new rule by December 23rd, 2024. So around the end of this year. And a lot of this is going to be pretty dry, so bear with me, but it is very important, if not a little boring, like so much of the law. So an overview of what the new reproductive health rule does. So in sum, it does 3 key things, and we'll talk about each of them, the first one in the most detail. So the first thing that it does is it creates a prohibition on disclosure. So this is the main feature of the rule, and it's its clarification that HIPAA's privacy rule prohibits the use or disclosure of PHI, so that patient information, for the purpose of investigating or imposing liability on any person for seeking, obtaining, providing, or facilitating lawful reproductive health care, or to identify a person for such an investigation. And we'll break down what all of that actually means in a second. It requires an attestation, so regulated providers, health plans, or clearinghouses must obtain a signed attestation that any requests for reproductive health-related PHI are not being sought or used for the prohibited purposes described in the prohibition on disclosure. And then notice of privacy practices. So covered entities have to modify their notice of privacy practices to support the reproductive healthcare privacy and put patients and other parties on notice of what they are and are not able to disclose or required to disclose. Okay, so the big piece of this new rule, or at least the kind of big change to the HIPAA structure, is the new prohibition on disclosure as it relates to reproductive health care. So again, I just kind of kept that broad definition that I already read through at the top of it, just so we can have that front of mind as we're talking through it. So again, it prohibits the use or disclosure of PHI for the purpose of investigating and imposing liability on a person seeking, obtaining, providing, facilitating lawful reproductive health care, or to identify a person for such an investigation. So some really important notes on what this actually means in practice. So the prohibition on disclosure, it applies to requests for information for purposes of criminal, civil, or administrative investigations. And this is really important because it doesn't only apply when, for example, law enforcement themselves are actually seeking information for purposes of investigation or prosecution. It also applies to administrative investigations and civil liability as well. And the Department of Health and Human Services describes seeking, obtaining, providing, or facilitating quite broadly, and they do so purposely because there's a great deal of fear about what providers are able to do, what they're able to speak about, what their patients are able to speak to them about, and so on and so forth. So they describe it broadly, giving the following examples of what would count as seeking, obtaining, providing, or facilitating. So covered activity could include, but is not limited to, activities such as expressing interest in, inducing, using, performing, furnishing, paying for, disseminating information about, arranging, ensuring, assisting, or otherwise taking action to engage in repro healthcare or attempting any of the same. And, I think the big takeaway from all of those words is that HHS is trying to cover scenarios where, for example, again, patient is located in Texas, goes to their provider in Texas and says, hey, I am pregnant. I think I would like to obtain an abortion. I know I can't do that here. Can you help me? And their doctor says to them, yeah, abortion is still legal in New Mexico. So if you are, able to travel, here are some providers that I know, that I could recommend or that I know are trustworthy. That kind of discussion would then fall under the definition of seeking, because you're expressing your interest in it. So that's kind of the takeaway there. And note, the new rule does not create a blanket prohibition against disclosure of certain types of PHI. So it's not type-based. It protects reproductive healthcare information from disclosure for certain purposes. So what you're looking at isn't necessarily the substance of the information sought, it's the purpose that they're seeking it for. Next slide, please.
Yeah, I just wanted to add the only substantive aspect, of course, is that it relates to reproductive health.
Yes, absolutely. And not just abortion. Obviously that is a big focus of my job is abortion rights, but it's not just abortion, it's reproductive health care generally. So things like contraceptive access, fertility care, all of that, what happens during a pregnancy and so on and so forth.
When you last got your menstrual period.
Exactly. And that kind of thing is also kind of circling back to the surveillance and criminalization piece of it, even in the cases of very wanted pregnancies, circumstances surrounding miscarriage and that kind of thing, where we have seen, unfortunately, a rise in law enforcement investigation. Okay, some more things on the prohibition on disclosure. So as we were talking, or as it says in the definition, so it only applies to lawful healthcare, and this is really important. So services that are legal in the state where the patient obtained them or that are federally protected. It does not protect information related to unlawful care, nor does it override any state abortion bans or, of course, create any sort of substantive right to healthcare that does not already exist. So this is really important. And, the question that kind of naturally arises from that is like, okay, so are we asking clinicians and doctors to determine what is and is not lawful in this really complicated, insane legal landscape that we find ourselves in? So what HHS has done with that question is created the presumption of lawfulness, which is, in my opinion, the most important part of this rule. So it creates a presumption of lawfulness, meaning that when a covered entity is presented with a request for PHI, that the reproductive health care at issue is presumed to be lawful, and the provider may accept the information given to them by the patient or other, party involved and accept that it's lawful unless the covered entity has actual knowledge that the care was not lawful, or the covered entity is presented with factual information that demonstrates a substantial factual basis that it was not lawful under the circumstances. So basically, if you're I'm going to keep using Texas as an example. If you're a provider in Texas and your patient comes to you and says, hey, I had an abortion in Colorado last week, I'm concerned about XYZ symptoms that I'm experiencing, you do not then have to go and conduct an investigation into whether or not this patient actually traveled to Colorado. You are able to take on its face what your patient says to you, unless you are then presented with actual facts showing that it has been unlawful. And this is really important because it gives providers a lot of discretion to push back and say, no, nothing about what my patient has told me indicates that the care that they received was unlawful. So I'm sorry, but I cannot disclose this information to you unless you're able to provide me with concrete facts showing to the contrary, which is going to be a lot more difficult to do if they can't get the information. So the prohibition not only covers not only the healthcare provider who performed the abortion, but any covered healthcare entity with access to the records. So a person's primary care physician in their home state would not be permitted to share PHI regarding a patient's out-of-state abortion for purposes of imposing liability. So again, obviously, if information is requested from that Colorado provider, the Colorado provider can say, no, I am permitted to perform abortions in this state, so I'm not disclosing this. But then once the patient travels back to their home state, let's say Texas, and goes back to their GP or whoever it may be, their OB, who has access to those records, is also able to invoke the rule and presume the lawfulness of the care provided. Next slide, please. Okay, so to kind of put this into context, and we touched on a little bit of this already, but some examples of when PHI likely is protected from disclosure. So when providers can say, no, I'm not going to hand that over. So interstate travel is probably the biggest one. Cases where a person travels from their home state where abortion is banned or restricted to obtain care in a state where it's legal, and then they travel back home. If the patient's home state then requests information about that care, if the covered entity is provided the care and knows it to be lawful, they can't disclose the patient's information. And this is true regardless of whether the covered entity I have a typo there, but it's true regardless of whether the covered entity provided the care or not. Federally protected care. So if a person accesses reproductive health care that's authorized under federal law, regardless of the state where the health care was provided, then that's going to be protected from disclosure. So this would be things like accessing contraception. Lawful care in the state. So if a person obtains reproductive health care in a state where that care is legal, then the PHI can't be disclosed for purposes of further investigating the circumstances of that care. Where a case falls within an exception. So again, this is a really important point, I think. So if you're in a state like Texas where abortion is banned and there are some extremely narrow exceptions for when it's permitted primarily to preserve the life or health of the pregnant patient, that's pretty much the only one that we have here. So if a person obtains an abortion in a restrictive state and that abortion falls within one of those exceptions, then the clinician can presume the lawfulness of the procedure and decline to disclose those records. So for example, if a patient in a life-threatening emergency here in Texas does receive an abortion and an investigation subsequently occurs and the entity that is having that information requested from them has no reason to believe that the care did not fall into the exception that's been asserted, then they can refuse to disclose. And that's really powerful. And then when the presumption of lawfulness applies, which is basically the other side of what I was just mentioning. So yeah, if the provider in question has no reason to believe that the care in question was unlawful, then they can refuse to disclose. Next slide, please. And I'm sorry, I know all of this is pretty dry and a little complicated. But okay, so examples of times when PHI may not be protected. So these are going to be cases where you may be required to disclose information. Unlawful care. So that's kind of the big one. You know, if disclosure is not prohibited, if the covered entity has actual facts demonstrating that the care was not lawful. So, you know, if your patient in Texas comes to you and says, hey, you know, I received an abortion from another provider in Texas that did not fall within a particular exception, and you're confronted with facts that tell you pretty point blank, this is unlawful. Unfortunately, you then may be required to disclose that information. And then purposes unrelated to liability, because remember, this is not a blanket prohibition on a type of disclosure other than its relationship to reproductive health care. It's all about the purpose. So if the request for PHI is not for the purpose of investigating a person or an entity for reproductive health care related reasons, then that care is not protected. So for example, the prohibition would likely not apply in these kinds of scenarios. So for law enforcement investigations into unlawful activities such as sexual assault, human trafficking, a request for disclosure to a health oversight agency conducting health oversight activities, such as whether reproductive health care was provided and appropriately billed, investigations into allegations of substandard medical care or patient abuse or neglect. However, disclosure is not permitted if the alleged basis for abuse or neglect is solely the provision or facilitation of reproductive health care. Investigations into whether a person submitted a false claim for reproductive health care for payment by the government, requests for PHI to investigate alleged violations of federal non-discrimination laws or other abusive conduct, or public health activities, those activities are not for the purposes of reproductive health care related liability. So in those cases where the purpose is divorced from that liability, then you likely can or are required to disclose. Next slide. Okay, and then I wanted to touch briefly on some specific considerations for telehealth, and it gets a little bit complicated here, and some of it is still kind of an open question. So I just wanted to do my best to highlight some things to bear in mind. So when we're talking about in-person care, you have a pretty clear idea of where the law considers the patient to be, where the law considers the provider to be, which states' laws apply. Of course, that gets a little bit more muddied when we're talking about telehealth, particularly with the rise of shield laws that states have passed to protect their providers who provide abortion services to either patients who are traveling from like physically traveling from a restrictive state to that state to obtain care, or in the case of some of the shield laws that allow the providers to actually prescribe medication into states that ban abortion. So for example, like a New York provider prescribing medication to me in Texas. So telehealth has its own considerations in cases where the patient is physically located in a restrictive state and receiving care from a provider in a state with a shield law that allows the provider to prescribe medication across state lines. And why this is so important is because you are then looking at how each of these states are going to define what is and is not lawful care, right? So in that case, all states with abortion bans in place are going to consider the patient's location to be the location where the abortion took place and would therefore argue that the abortion was unlawful. So like the example I just gave, if a Texas resident obtained mifepristone via telehealth and took it at home in Texas, the state of Texas is going to argue that that is unlawful care and therefore it's not protected by the rule. And so states with shield laws in place, they may refuse to comply with a subpoena related or other request for information related to that healthcare that they provided lawfully, and their state shield law may protect that provider from having to disclose that information. That same refusal may not apply to other healthcare providers in a person's home state if that state is an abortion restrictive state. So for example, again, if that patient, do you mind going back a slide, Khadijah? Sorry. So yeah, like New York shield law, can you back one more?
Yeah, I'm so sorry.
No, you're fine.
I tried to see what the person's Q&A question was, and in doing so, I failed in
No
my
worries.
duties.
No
Apologies.
worries. Yeah, so this would be a case where like, New York has
Wait,
a
we were
shield.
looking, sorry, one second. We were on the one with New York.
Mhm.
Ah,
Oh,
hold
yeah,
on.
go for it if you
Yeah, that's what I'm saying. I'm like, where's New York? Where's New York?
keep going. I think one or
There we
two.
go.
There we go. Perfect.
Sorry about that.
No problem. So, okay, yeah. So states with shield laws, yeah, so for example, New York shield law allows telehealth across state lines. So providers in New York are able, if they choose to do so, to prescribe medication abortion across state lines, even into restrictive states. And the state shield law will protect, well, theoretically will protect that provider from future liability. So if patient A is located in Texas, obtains medication from a New York provider via telehealth, and then they complete that abortion in Texas, then the New York provider can refuse to provide records based on their state shield law, but a Texas provider who performs, let's say, follow-up care may not be protected from disclosure, right? So again, let's say you have the abortion in Texas using medication, some complication or concern arises, you go to an ER, you go to your OB, you go to whoever, and they perform follow-up care. That person, and then that person has records requested from them related to that care, they may not be able to assert that the care was lawful because Texas is going to consider that care to be unlawful, and that provider is not protected by a shield law because obviously Texas does not have a shield law in place. And a lot of these questions, as I mentioned, are open legal questions, right? We haven't really seen these scenarios play out in litigation yet. I would venture to guess that we inevitably will in some form or fashion in the coming years, and we'll see challenges to those shield laws and to the ability of providers to prescribe over state lines, kind of in direct defiance of another state's abortion ban. However, for now, what we need to know is that providers need to be really cautious about how they document reproductive health care in these cases related to telehealth, even if you are in a state with a shield law, be cognizant of whether or not your patient is located in a restrictive state and therefore how you document that information. Okay, so that is the prohibition on disclosure. I know that was a lot. The other two aspects of this rule, which are pretty consistent with HIPAA generally and not nearly as complicated, but are the attestation and notice of privacy practices. So the attestation, regulated providers, health plans, and clearinghouses have to obtain one that saying that any requests for reproductive health-related PHI are not being sought or used for the prohibited purposes that we just talked about. According to HHS, the requirement would apply where the requester is making the request for any of these reasons. So disclosure for health oversight activities, for judicial or administrative proceedings, for law enforcement purposes, or disclosures about decedents to coroners or medical examiners. And then the notice of privacy practices, covered entities have to modify their notice of privacy practices to support reproductive healthcare privacy and put their patients on notice of that change. So the NPP has to describe the ways in which the covered entity may use and disclose PHI for treatment, payment, or healthcare operations, as well as each of the other purposes for which the covered entity is permitted or required to use or disclose it without the individual's consent. Okay. Okay. Sorry.
Y'all did it.
Yeah, I was just glancing at the Q&A.
You made it through the dry part of this presentation. So we do have some stuff in the Q&A. I just want to uplift because I think we should just address HIPAA questions now before we go pivoting.
Okay. All right. So first question is there a risk that certain clinicians could interpret actual facts in such a way that they may choose to disclose, or would there be consequences if they disclose and cannot demonstrate that they had actual facts? That's a really excellent question. And I think, the answer is kind of twofold. I think, yes, there is certainly a risk of how clinicians choose to interpret whether or not they have facts showing that care is lawful. And that is the problem of asking medical providers to interpret the law and interpret what is and is not lawful, rather than just allowing them to do their jobs. And of course, while many providers are supportive of their reproductive health, their patients' reproductive health care choices, not all of them are. And so, yeah, there's absolutely a risk that clinicians could interpret that in a way that allows them to disclose. In terms of whether there are consequences, you are able to.
Where I was going to say you can come over to me because yes.
Yes, great. Take it away.
So yes, there are consequences for HIPAA violations. They vary depending on the willfulness of your violation. So if you can show that you really, really, really thought that it was illegal and that's why you shared, then the civil penalties will be lower. But HIPAA violations are one area where the federal government has tried to develop a really consumer rights perspective. And it's like the one area that I think privacy is taken seriously really anymore. So yes. Yeah. I mean, in the grand scheme of things, it's a slap on the wrist, but yes, there can be consequences. If it's willful, it can be up to $10,000 to $50,000 per violation with a maximum $250,000 a year for repeated violations. So
yeah. So
hopefully,
there is
I'm not going to lie. I'm hoping Vanderbilt gets some consequences for releasing all of their gender affirming care patients' data.
Yeah, and I mean that's a great point as well. It's a conversation for another presentation, but the same kind of surveillance and privacy concerns are arising, in terms of gender affirming care and trans and LGBTQ healthcare issues as well. So yeah, no, it's a great question. Okay, another question is how about patients going to other countries for an abortion? Yeah, so I mean the disclosure is going to relate to the entity that it's being requested from here. In terms of, I mean, that's a good question. I mean, it's a complicated question because international laws on abortion vary pretty wildly from country to country. But yeah, I mean, if let's say you live in Europe, you have a legal abortion, you move to Texas or you come to Texas for vacation for whatever reason, and that, seek follow-up care, that information is requested and your provider has no reason to believe that the information that you're providing indicates that it was an unlawful procedure, then yeah, it would still apply. And then will the slides presented here be made public? Yeah, I would think we would share our slides out. I know we have Keisha, I think, already shared it, but if not, we'll share. We have she created a beautiful document that encapsulates pretty much exactly what we're going through right now. So if not the slides themselves, then certainly that. But yeah, we can definitely share the slides.
And
Okay.
the resource has been placed in the chat.
Awesome. Perfect. Yeah, and it goes through more or less exactly what we have talked about. So okay, with that, objectively the most boring part of this presentation, we can turn to the Supreme Court and a couple of the decisions that happened this last term in the last couple of months that impact the provision and receipt of healthcare. So I can take the first one, and then I will toss it over to Khadija to talk about EMTALA. So, and I'm going to talk pretty fast and in pretty broad strokes about this because they're really complicated, messy cases and get really in the weeds. And you've probably heard about both of them. So the first one is Alliance for Hippocratic Medicine versus FDA. So this is a case where the plaintiffs, the Alliance for Hippocratic Medicine, are a group of anti-abortion doctors, openly anti-abortion doctors, and provider groups, and they challenged the FDA's approval of mifepristone, one of two drugs used in a standard medication abortion. And they argued that the FDA acted improperly in approving those medications, and, kind of undergirding their entire claim is the idea that mifepristone is actually extremely dangerous and should not be permitted for this purpose. But yeah, and they have their own studies and all of that they presented to the courts. So the Supreme Court ultimately, after a huge procedural process, ended up rejecting the case on standing grounds, finding that the plaintiffs could not show that they were harmed by FDA's actions. So in order to bring a lawsuit, you have to have what's called standing. You have to be able to show that you have been harmed, that you don't just have kind of a generalized grievance with whatever the law is. And in this case, these providers and provider groups, of course, neither take nor prescribe mifepristone. It is against their stated mission and beliefs. And so being able to show that they were personally harmed by the FDA's approval of mifepristone was impossible, and they were unable to do so on the facts presented. So why this case matters, because ultimately it was thrown out on standing, right? It wasn't thrown out because the Supreme Court actually evaluated the merits of the case and FDA's actions and the safety of mifepristone and all of that. So you could say it was thrown out on a technicality. So access to medication abortion is critical. Again, I know you guys know this more than I do. At this point, it accounts for over 60% of all abortions, and it's especially critical for patients, not only patients who are in states with bans and restrictions in place, but also patients who may be in states where access is legal, but maybe in a maternity healthcare desert, maybe in a rural area, may just not be able to take time off work, get childcare, travel, do all of the things involved. And medication abortion via telehealth can bridge that gap, right? So it's really critical preserving access. And again, although SCOTUS ultimately came to the right conclusion and tossed out the case on standing, the case should never have moved forward in the first place. And that is not me just saying that, because obviously this is an issue that I have my own opinions about, just based on extremely well-established precedent. This case should have been tossed out at the district court easily, over and over again. And the fact that it even made it to SCOTUS is frankly a little bit very alarming. And again, the Supreme Court did not rule on the merits question of whether the FDA acted improperly in approving mifepristone. And this is important because it means that other litigants are able to challenge it again, because we don't have precedent saying, no, the FDA acted properly, case closed. And so actually the case has already, the states of Kansas, Missouri, and Idaho have already moved to intervene in the case, wanting to bring it on behalf of themselves as states, arguing that their residents have been harmed by mifepristone, among other claims. So they're fighting to be able to bring that. And if not them, there will almost inevitably in the next, I would venture to guess, year, once we see, honestly, the outcome of the election and a number of other things, it'll be continued by future litigants. So how do we move forward? So for now, mifepristone remains available and unchanged, for the time being, but an anti-choice administration could change that, potentially with or without congressional approval. Mifepristone continues to be unavailable in many states, depriving people of access. So those are your states where abortion is banned, which obviously also includes medication abortion. And that's, again, where the telehealth piece and the interstate travel pieces come into it. And then SCOTUS's decision overturning Chevron deference, which we don't have the time to get into today, but basically overturning the deference that's given to executive agencies necessarily undermines the FDA's authority and gives the courts more room to second guess that authority. If the case is brought again by different litigants, the court will have more bandwidth to substitute its own judgment. So with that, I will turn it over to Khadijah to talk through the second case.
Yes, thank you so much. So our case number 2 that relates directly here is the Moyle versus United States and Idaho versus United States. They ended up getting joined together once they reached SCOTUS. And what happened here is that Idaho enacted a total abortion ban, meaning that they not only had a ban like many states do, with exceptions, but they actually went above and beyond, and made it so that the only time that somebody could seek an abortion or provide an abortion or be involved in the provision of an abortion without penalties or criminality was where the pregnant person's life was in danger. So generally it's life or health. And we have this federal law, longstanding 40-year federal law, the Emergency Medical Treatment and Active Labor Act, that protects patients in, not only emergency, like about to die situations, but also situations where their health is at risk. So something where, their quality of life could be significantly reduced if they don't receive care. So under EMTALA, that means that if a person, is hemorrhaging and the doctor determines that they may lose their fertility, right, if they don't intervene, or have long-term, other long-term harms, that they would be able to deliver an abortion and be protected under the law. However, in Idaho, they were saying that no, it would just be if death was a risk. Now they walked it back. Originally it said if death was an imminent risk, and they said no, we didn't mean that. So they basically tried to communicate in oral arguments that there was no daylight between the two, that they were just all, everybody's kumbaya, getting along, everything's fine. But in reality, everything's not fine. And so the fact of the matter is that because of that, the lower courts blocked the part of the law that prohibited health-saving abortions because it conflicted with EMTALA, period, full stop. In January, the Supreme Court agreed to hear the case and actually stayed the lower court's orders, which meant that Idaho was free to enforce its ban and to say, even if you're at serious risk of harm, morbidity, as we call it, instead of mortality, is at risk, then it doesn't matter. That's you could still be criminalized for getting an abortion. So now the weird thing is that, once again, they basically said, oopsie, even though, precedent, the facts of the case all were at, in front of them the whole time. They basically said, because of what we heard at oral argument and because of evidence provided to us since we accepted the case, we're going to say that we shouldn't have heard it. When again, the fact is that they actually had access to everything they needed to not hear the case. So why does this matter? It's because they left people in Idaho, wondering what to do in terror, right? Providers fearful to provide care, patients fearful to receive care. People were airlifted out of the state during the months that it was before the Supreme Court, and harm was caused by our Supreme Court justices for, making people wait to get a ruling. And they still never got a ruling, right? They never got a ruling on the merits. The the stay is back in place, hooray! But it doesn't actually tell us what the law is. So again, once another person brings a case, we don't know what could happen. So the other problem is that in their decisions, they relied on certain misunderstandings in oral arguments to really threaten EMTALA's supremacy and threaten its scope. So it looks like the majority has misinterpreted EMTALA to sort of have a deferential relationship with conscience laws, wherein a person, if a patient has their health at risk or their life at risk, and they're, in a healthcare desert where nobody else is around to treat them, the Supreme Court is saying that, okay, let them die. That's really what it said. That conscience laws would supersede, and a person would be fine not providing care in that circumstance. HHS about a week ago or a couple of weeks ago has tried to clarify that no, that's not the case, and we're hoping that doctors hear it loud and clear that in a healthcare desert, when somebody's at risk of death or injury, you are still responsible for their care, and you still have to do whatever it takes to restore them to equilibrium, and should not just leave them there. So what's going to happen? It's going back to the Ninth Circuit for now. It's probably going to be right smack dab in front of the Supreme Court, either this case or a similar one happening in Texas. And we are just all sitting here, twiddling our fingers, waiting for them to develop some clarity on not only issues of standing, but federal supremacy. We need to know, right, when a federal law is actually, the law, and be able to act accordingly. And doctors need to be able to practice medicine without sitting there wondering, right, day by day, what their rights are. Alyssa, do you want to talk about the Comstock Act, or would you like me to?
Yeah, sure. I'm happy to. And then just jump in if I miss anything, which I will, because it's really complicated and annoying. So just a couple of, coming off the heels of all of the legislative sessions earlier this year, where a whole bunch of changes to the law happened across the states, as well as the Supreme Court decisions at the federal level. There are a ton of trends and things that we're watching to kind of see what the landscape looks like and is likely to look like in the coming months and years. And so we pulled out a couple that I think are particularly important. Of course, it's a very non-exhaustive list, but just wanted to highlight a few, particularly ones that you've maybe heard about in the news. So there's been a lot of talk about the Comstock Act, which is something you probably had never heard of until a few months ago, and frankly, never should have had to have heard of. But so what the Comstock is in its modern form, and again, Keisha created a wonderful one-pager on this for y'all. But so in its modern form, the Comstock Act refers to a series of provisions that prohibit the use of the U.S. Postal Service, as well as other carriers, so FedEx, UPS, to send obscene materials or materials used to produce abortions. And the obscenity portion of that law has rarely, but has been used for prosecutions in recent decades, primarily related to hardcore pornography. However, the provisions of the Comstock Act related to materials used to produce abortions have been dead for decades. Like, that's just been kind of dead law that's just sitting on the books, right? So, as I said, it's gone unused for decades for those purposes, but some lawmakers and activists argue that it should be revived as a method to federally ban abortion. They're not necessarily putting it in those terms, but that would be the functional reality of it. And the most immediate argument being made by folks who oppose abortion is that Comstock should be used to ban the mailing of medication, so mifepristone, misoprostol. But the language of Comstock is actually quite broad, so it's materials used to produce, procure abortion. So that would take into its, like full extent, interpreted broadly, would pretty much include anything, even things needed for procedural abortions, which obviously have to travel through the mail. And so the Biden administration has indicated when these arguments were first raised after Dobbs that Comstock only applies to unlawful abortions and can't be applied to prohibit the sending of materials for lawful abortions, which would require you to like look to the intent of the sender and all of that, and functionally means that Comstock is not usable for abortions. However, folks who disagree with that interpretation have argued that an administration hostile to reproductive rights could order enforcement of the Comstock Act in a way that functionally bans abortion nationwide without the need to actually pass through Congress a federal abortion ban. And this is really important, and I never want to fearmonger. I never want to kind of use fear as a tool. And hopefully this will never come to fruition. But, we've seen a lot of things happen in the last 2 years that if you'd asked me 3 or 4 years ago, I would have kind of rolled my eyes and said, come on, that's not going to happen, right? And so having learned that lesson, it is just something that we're really watching and that we're watching the narrative around, and something that I think it's important to be aware of. Next slide. Okay. Another huge thing, again, that's been kind of all over the news in the last year, particularly since one very notorious Alabama Supreme Court decision, is the idea of fetal personhood. So fetal personhood laws are laws that seek to give fetuses and embryos in utero the same rights as a person, as any person. So they're on the books in actually over a third of US states. And what these laws look like, it can really differ state by state, and it can be kind of sneaky. So they don't usually arise in laws explicitly relating to abortion, actually. Instead, they're going to come up in things like the family code. So things like granting child support, the right to obtain child support payments prior to a child being born, things in the tax code, being able to apply tax credits for unborn fetuses and embryos, or in the criminal code, so things like wrongful death, or even statements about the scope of the Constitution, state or federal constitutions applications. So statements like saying that, the equal protection clause, guarantees of life, liberty, so on, apply with equal force to unborn children, to fetuses and embryos, and so on. So this is really important. Fetal personhood arguments are a way to, arguments and laws are kind of a way to restrict reproductive health without explicitly passing reproductive health care restrictions, right? And these are the arguments that led to outcomes like what happened at the Alabama Supreme Court earlier this year, which you guys may have heard about, where basically frozen embryos were destroyed in a lab. The families who owned those embryos brought a lawsuit for the destruction, challenging not only a destruction of property, a breach of contract type argument, but also argued that it was a wrongful death of a child. This is a novel argument because they're asking the Alabama courts to accept the idea that the frozen embryos constitute a child for the purpose of state law. Went up to the state Supreme Court. The state Supreme Court agreed with those families, leading to the cessation of all IVF services in the state pretty much overnight. And several IVF clinics have shut down permanently. And there are, in Alabama, they did end up passing legislation in the wake of this decision to restore rights to IVF, basically to put a Band-Aid on what happened as a result of that court ruling. But in other states, there's a lot of concern that similar rulings could come out. And as I said, there are fetal personhood laws somewhere in the legal codes of all of these different states. And so the potential is there. And, I can tell you kind of anecdotally from having talked to a number of our provider partners that folks who are in really restrictive states have been advising their patients to move their embryos out of state. So these laws could have extreme consequences for medicine and the law, because it brings in factors like how, when a patient presents in an ER, for example, how do you prioritize the life of the fetus versus the life of the mother if both are in danger, but under the law of your state, they are considered to have equal rights? How do you do that in a way that doesn't expose you to liability, doesn't expose your patient to undue harm? Increased criminalization and surveillance of miscarriages, as they're treated like the death of a child, of a born person, right? So you might look at something like somebody drinking alcohol before they knew they were pregnant, or medicinally using marijuana after they knew they were pregnant, or doing any number of things, and potentially look at that as cause for investigation. Increased criminalization of and surveillance of conduct during pregnancy, looking at it through a lens of potential harm or neglect inflicted on a child. And then severe limitations on access to, obviously, abortion, but also certain fertility treatments and even certain forms of contraception. It also just leads to a lot of kind of common sense absurdities. Like if, a fetus in utero is considered a person with all of the rights of a person, then what do you do with an incarcerated pregnant person? Is their fetus wrongfully incarcerated without due process of law, right? So it leads to all of these different kind of legal absurdities and medical impossibilities. And it's a really important thing to keep an eye on. Next slide. And then the last one, and we are rapidly running out of time, so I'm going to talk really fast. Ballot initiatives. So again, as I'm sure you've heard, a number of states are looking to place questions related to abortion rights on their state's ballots. And if passed, these would enshrine the right to abortion and other reproductive health care procedures into the state's constitution. This is important because constitutional amendments hold a great deal more weight than just legislation, and they are a lot more difficult to overturn. So for example, if control of a state's legislature or the governor or whoever changes from one party to another or one policy position to another, it is a lot more difficult to undo constitutional amendments. Some states like Colorado, Florida, Maryland, and Nevada have already succeeded in having those questions placed on the ballot, and voters will be able to directly vote in November. Others are still in the process of fighting to get those measures on the ballot. I mean, the number changes all the time, but I mean, there could be as many as something like 12 states having it on the ballot. And of course, as you probably heard, Ohio passed it last year. Abortion has succeeded every time it's been placed on the ballot thus far since Dobbs. So we're hopeful that these wins will fundamentally shift the reproductive healthcare landscape and allow folks in states where access is otherwise not protected to reclaim access, at least to some extent.
Yeah, I just want to pipe up and say, these ballot initiatives, although they are risky, depending on your state constitution and the makeup of your state populace and sort of the amount you can rally folks to participate in, the civic process, they can be really important as we enter this phase where, the Supreme Court justices, specifically Alito, have expressed significant support for fetal personhood. And also, Comstock is being written into city laws. And, there's just sort of this spreading, through Project 2025 and other extremist initiatives, this spreading, erosion of sort of, assumed even medical basics in the law across the country. So something like this could, because of state preemption, could really have an incredibly positive effect, as we see it has in Ohio.
Yeah, absolutely. It's really important, and it's a really unique way for citizens to directly impact these issues. And really one of the first times that we've ever seen ballot initiatives used in this kind of a way. So just real quick before we wrap up, what can you do? This is a question we get all the time. This is a question that I ask myself all the time. A big part of it is own your expertise. As providers, you're experts on how to take care of your patients, you're experts on how to practice medicine, and you're also experts on how restrictive laws interfere with that care and harm patients and harm you. So we're in a situation where lawmakers, judges, and justices are substituting expert medical judgment with their own, often openly ideologically motivated determinations. And as providers, you're in a powerful position to push back. You speak with a very powerful voice here. Partner with advocacy groups. If these are issues that you care about, groups working for equitable healthcare need medical voices in their midst. I can talk about the law all day, but there are severe limitations to my ability to accurately talk about the practice of medicine. Reach out in whatever capacity fits your skills, your time, and your passion. Like, if there's a part of this that matters a lot to you, that you feel really suited for, do that. If there's a part of it that feels fun and exciting, do that. Do what feels right to you, and put your efforts where it will be the most valuable. Educate yourself and others. This is such an important one. So just educate yourself and others about what the law does and does not require with respect to HIPAA, with respect to the other things we've talked about, so that you can be an effective advocate for your patients and also for yourself and your colleagues. Where you're unsure, reach out to groups like L4GG. We are quite literally here to help. And then I have to say, in the run-up to the election, talk about voting as a health equity issue. Voting and healthcare are intrinsically linked, especially right now with our courts. And it's critical that we talk about them as two sides of the same coin. The next administration will have a huge impact on access to healthcare at the federal, state, and local levels. And it's really important that we encourage voters to make those decisions with their healthcare in mind. And then one quick, super shameless plug to our if you want more information about state level reproductive health policy, feel free to sign up for our policy resource hub for reproductive rights, the hub. It's available at l4gg.org/repro. And in it, we update the state of abortion law in every US state and territory every single business day. So you can stay up to date on what exactly your state permits and prohibits. It also includes all of the archived editions of our Repro Health Digest that we publish every 2 weeks, and all of our reproductive health related media pieces that our pro bono attorneys are collecting. And then I have dropped our emails there as well, which I will drop into the chat. And with that, I will turn it over to Q&A. So, okay. Let's see. Okay, so one of the questions asked, does a woman have more success in having an abortion due to rape? So in terms of the law, that depends entirely on the state that you're in. So in states that restrict access to abortion, many of them do not have, I wish I had the number off the top of my head, but many of them do not have exceptions for rape or incest in the law. Texas does not. So it's really just going to be on a state-by-state basis. And I will also flag that in the states that do have rape or incest exceptions, there are often other restrictions that are attached to that. So for example, they may prohibit abortion until 6 weeks in pregnancy, but allow it in cases of rape or incest until 12 weeks in pregnancy or 20 weeks in pregnancy. So there's still those restrictions on it. Also, most states that have those exceptions have reporting to law enforcement requirements, which is obviously not in any way a medical necessity to provide that care. But so the law will say something like, abortion is permitted in cases of rape or incest if the crime has been reported to law enforcement within 30 days or 140 days or whatever that state's time limit may be. And then how you are required to document that reporting, again, depends on state by state. Honestly, all of that information is in the hub if you want to look at what your state specifically allows and prohibits. We have all those details linked in there. But yeah, I mean, that's actually something, it's a good question, and I'm glad you asked, because I think it's something that working in this space, I can sometimes forget that, like, it is actually quite striking to learn that, my state does not allow this procedure, even in cases where I have been the victim of a terrible crime. And people sometimes assume that states do have those exceptions where they don't. So that's a great question. Yeah. I will say as well, like, even in, on that same note, even in cases where, or in states where abortion is permitted in cases of rape or incest, oftentimes people won't invoke those exceptions and won't seek care because they don't feel safe seeking an abortion in a really abortion hostile environment, or they don't feel safe reporting the crime. That's especially true in cases of incest, where, definitionally the person who has perpetrated the crime is someone who's a family member, and the states don't usually have carve-outs for reporting requirements in those cases. And so you may be required to report to law enforcement on your, father, brother, uncle, whoever it may be. So yeah, that's a great question.
Yeah, and sadly, you really don't have to go far to find horror stories of children who are victims of incest, being forced to give birth because of exactly that situation. It's been happening regularly. And ProPublica and other media outlets have been covering those stories, and we actually cite to those stories in our digest.
Yeah, absolutely.
Any other questions? Y'all have hung in with us incredibly long. We want to know what, did any of this raise any curiosity for you? You have two lawyers here, just ready and able. Oh, here we go to answer your questions. We have, if the Comstock law were enforced, could that impact shipments of surgical supplies that are used for other gynecological procedures? Why, yes, it could. And that is a vast concern. It could also lead to the wide scale, tracking and monitoring of your communications about said purchases. So, it's nerve wracking because the enforcement piece, right, as it's discussed by architects of Project 2025 and others, is dystopian. It's Orwellian. It's beyond my imagination. It takes, I can't even begin to think about how people decided these things, or like how did they think them up? Because they're so invasive to professionals' ability to do their job. And again, I just keep coming back to, if you have to be worrying about these things, you cannot provide, the quality of medical care that you would be able to otherwise. Hello, everyone. This is Elliot. Yes. And it's, I will say it definitely, hey, Mommy. Hi. It's, as one of you noted, it makes the prospect of intimacy rather terrifying. And, a lot of people are talking about, stockpiling contraception and, preparing for the worst. The rhetoric on the political, front is so frightening. And again, I think the good news is that the louder we get in pushing back and speaking out about how horrifying it is, the more they realize it's not a winning strategy. That doesn't mean they're not going to try it. They're just going to hide it more. Like Alyssa was pointing out, in these fetal personhood laws, which they hide everywhere, right? But yeah, I think it's a very important time. Your voices are more important than ever. Yes. And, it's the kind of thing that we all would love to have stopped talking about ages ago. But I think, telling your stories, writing op-eds, engaging with your communities, and also pushing your yes, institutions, hospitals, other providers, insurance companies, to make things crystal clear for patients as to what the law is and what their protections are under things like HIPAA. It goes a long way. So please do check out the HIPAA resource, check out Comstock, get scared. No, take action. There is a law that seeks to at least hinder Comstock's effect on potential abortificants. So you can look into that and stay active with DFA, where I'm sure we will stay in clear and constant communication about other ways that you can help.
Yeah, absolutely. And I know Keisha dropped our emails into the chat, so please don't hesitate to reach out if anything else pops up for you that we didn't cover or that you think of. We're always available. And thank you so, so much for your time.
Oh my gosh. Thank you both. Thank you so much.
Absolutely.
So I definitely love to, conclude by just saying and thanking again our speakers for a very thought-provoking, insightful, scary discussion with a wealth of information. Greatly appreciate you both for your time and expertise tonight. And for our attendees, did you like what you learned? If you would like to join us on August 22nd. We will have our next session, our next advocacy grand rounds is called Now What? Public Health Impacts of Supreme Court Term 2023 through 2024. So this will be a panel session that will provide clinicians an overview of the recent Supreme Court decisions from last year and this year's term and their impacts specifically on public health. Panelists will describe short-term and long-term impacts on public health, as well as the clinical practice for physicians and other healthcare professionals. Again, this presentation will be on August 22nd, and I just dropped the link to register if you're interested. Again, free opportunity here to join us then at 8 p.m. Eastern Time. And again, thank you to all of you for being here and for all the work that you do on behalf of patients and community members. We hope that you will become an official DFA member today, as one of the #1 reasons that doctors, medical students, and advocates join DFA is to be with like-minded people that share the same values and priorities. So again, thank you all so much for your time this evening and enjoy your evening. Stay healthy, stay hydrated, and take care.